Hello, welcome to this short session today. We're going to talk about involuntary alienation. Now, there's two forms of ownership that can be transferred. One's called voluntary alienation and the other one's involuntary. Today, we're going to specifically look at involuntary alienation. What does that term alienation mean? Again, to alienate or transfer, get rid of. Okay, so you'll see that term. You need to become familiar with it, because you'll see it on the state exam expressed as alienation. Other terms, transfer, okay, but they both mean the same. My name is John Enzing. I am a real estate instructor licensed in both Louisiana and Florida. My specialty is to private tutor you, the student. I prep you for the exam, non-credited hours, just to get you ready for your state exam for a pass the first time. Cover common law, and we can cover the state portion too as well. So if you need some private tutoring, go to privateturingsession.com, privateturingsession.com, book a session, or you can email me at john.enzing@gmail.com. All right, let's dive into this. Involuntary alienation. What are we talking about here? Well, it comes under the deed, title, transfer of title, and the recording of title. So anytime a contract comes to fruition under a voluntary alienation, that means somebody voluntarily transferred the property. It could be a sale, okay? At the act of sale, you got the grantor transfers to the grantee, got a new owner, okay? We're specifically talking about involuntary. Again, involuntary is according to law, okay? Not the owner's desire to transfer it, but the law is granting that or making that happen, okay? So what is involuntary alienation? Again, without the owner's consent, it is the law that's transferring. All right. Now, the first one we're going to look at is called transfer by descent and distribution. Okay. What is descent and distribution? You need to know this now. Pay attention. If someone dies intestate, that's the term we're looking at. Intestate means they die without a will. So you have a property owner that may have children. Let's say they're grown and married and away, and they've got an estate, and the owner of the estate passes. But there's no will. There's no direct order on paper who the owner wants the property to go to. So the state law, and this is throughout the lands, each state has their own descent and distribution laws, but the term descent and distribution means the law is going to decide. If there is no will that the owner grants to give the property to in succession, the state will determine through the descent and distribution law who's going to get the property, okay? So the state determines it. Remember, someone dies without a will, they die intestate, there is no will, they don't make any determination, but the state laws will determine who gets that property. They're called heirs. Those are the people, or those are the descendants that the property passes to, okay? Those are the legal descendants, according to law. Remember, intestate, this is coupled with involuntary alienation or involuntary transfer without the owner's consent, okay? Owner passes, again, without a will, the law of the state is going to determine who gets that property. And the last one we're going to look at is escheat. Okay, escheat is, again, someone dies intestate, but there is no heirs to receive. There's nobody to give the property to. Okay, well, if there's no people to give the property to, or successors, heirs to give the property to, they don't want to leave the property blighted, right, and just vacant and abandoned. So the law says under escheat, someone dies intestate, no heirs to give the property to, the state will have the property transferred into their ownership. Okay, so the state will get the property back. Okay, remember, involuntary alienation without the owner's consent. First one, the transfer by descent and distribution. Okay, this is where the law decides someone dies without a will, called intestate. The actual heirs will get the property based on the state laws. Okay, not the owner's wishes, but the state laws. The owner wanted it under their consent, they would have wrote a will, but this is without a will, okay? Involuntary, remember, without the owner's consent. And escheat is when someone dies intestate again, but there are no heirs for the property to succeed to, That state law says the state gets the property back and they take ownership of it. Okay? Hey, listen, I hope you enjoyed this short session on involuntary alienation. Again, if you need help with tutoring, privateturingsession.com, privateturingsession.com, book an appointment, and let's clean some things up. Look forward to hearing from you. Bye now.